All right, well, welcome back for our final panel on the regulation of hydraulic fracturing. I'm Jonathan Adler. I'm a professor here and director of the Center for Business Law and Regulation. Thanks to all of you for sticking around to the last panel. You won't be disappointed. A few housekeeping notes. After this panel, there will be a reception in the lower rotunda. So please join all of us and the staff of the Law Review for that and our speakers for that afterwards. Also, at the reception, there will be a sign-up for those of you that want to receive a hard copy of the volume of the Law Review that will contain the papers from the symposium. I'm told there'll be a sign-up up there so you can leave your address and you'll get mailed a copy of the bound volume when it gets published. For those of you that aren't familiar with traditional law review publication schedules, it will be several months, but it will be worth the wait to get the papers that we've heard about today. But enough from me. Let me just very briefly introduce our panelists. As has been mentioned before, full bios are in the CLE booklet. But first, we're going to hear from one of our alums, Joel Zipp, who is senior counsel at Holland and Knight in Washington, D.C. Then we're going to hear from Chris Kulander, who is assistant professor of law at Texas Tech. And although I said I wasn't going to say much about the individual bios, I couldn't help but noticing that he has a PhD in geophysics focused on petroleum seismology. Is that correct? So if you have any real technical questions, he's your guy. Because apparently he really knows something about how all of this actually works. Then we will hear from John Nolon, who is a professor of law at Pace University, and then from Elizabeth Burleson, who is associate professor of law also at Pace University. But again, you didn't come to hear me, you came to hear them. So let me pull up Joel's slides and turn the podium over to him.
Thank you. I have a master's in geology also, but a PhD trumps that any day. So, and I forgot everything I knew. But I'm happy to be back here. This is the first time I can come back where I don't have to pay to be here. So it's although I'm not getting paid to be here, but maybe next time. So I'm going to basically take you through the proposed rule that's been issued by the Bureau of Land Management. But I also wanted to comment about the popularity of this whole fracking issue. I bring this up because my wife is a groupie of the Rolling Stones, and they came out with a new song about 7 weeks ago, which mentions fracking. So that's probably the bellwether, at least for my generation anyways. So I'm going to go through the first couple of slides quickly because this is just some background information on a horizontal well. I mean, if this is included in the materials, you'll see this. It just shows the horizontal portion of the well where the fracking is, and we've gone through some of this earlier today. This is the Energy Information Administration map that's put out and updated, almost at least once a year, I think, on the major shale producing basins in the country. Oh, wait a minute, I have a slide missing here. I think there's some text that was missing on this slide. I don't know why that happened, but in the original slide, there was some text in the upper left-hand corner there citing the Groundwater Protection Council report, Modern Shale Gas Development in the United States, a primer, which I think is included in the materials. But if you look at the executive summary there at page 4 and also page 15, you'll see that hydraulic fracturing is the preferred stimulation method for gas shales. And as a result, hydraulic fracturing is a, quote, technological key to the economic recovery of shale gas. So as you probably already knew, and certainly heard during the day, fracking is really the major technological advancement and the way to extract natural gas and oil from these formations. This is just an old picture of the, just so you get a sense of what it looks like. This is the Utica Shale at the surface in New York State. This is what's being drilled in the subsurface in the region here to obtain natural gas and natural gas liquids. Okay, I just want to put this in context. We'll go through a few PowerPoints here. The BLM's proposed regulations were issued in May. Comments were submitted in September. In my discussions this week with some senior officials there, to get this rule out by the end of the year is, quote, the highest priority of the department. I don't think it'll come out the end of this year because the practical side of this is that government employees try to use up all their vacation time before the end of the year. And I don't really think it's going to come out until probably the end of February. But it'll probably be the first federal rule we're going to see, any statement on, you know, what the federal government's position is on hydraulic fracturing. So this is, you know, I think a pretty significant situation. This rule is going to cover about all the federal lands and all the tribal lands, about 750 million acres. So the new rule would actually amend existing rules. There's an existing set of rules that's administered by the Bureau of Land Management today, and these rules cover oil and gas exploration, development, and production operations on leases which are basically issued by the U.S. or, you know, negotiated with Indian tribes. And under the current regulations, prior to any subsurface disturbance or the commencement of drilling, you've got to file what's called an application permit to drill, or APD. And the current rules actually cover in a decent amount of detail what needs to be provided in that application. The current rules say if there's any non-routine hydraulic fracturing that further approvals are required. That was so vague and uncertain in its application that is one of the reasons that the new rule, proposed rule, was issued. The current rule also contains certain environmental standards and requirements. In fact, depending on what you are proposing, it could end up in triggering the need for a full environmental impact statement. The water used in drilling operations under the current rules must be disposed of in either subsurface injections or in approved surface pits or by other means. And you know, any untoward events that occur have to be reported. There are about 3,400 wells per year that are currently drilled on federal and tribal lands that use fracking techniques, and this is about 90% of all wells drilled on these lands. So the new rules are actually intended to modernize, according to the BLM, to, quote, modernize its management of well stimulation activities, including hydraulic fracturing, to ensure that fracturing operations follow certain best practices. And as was mentioned before, you know, fracking is a well completion technique. This is something that takes place after the well is completed, where you re-enter the well to enhance movement of oil or gas to the wellbore. So, and the new rules would apply to all well stimulation. Hydraulic fracturing is just one of several means of stimulating a well. So the proposed rules are really divided up into what happens before the stimulation, what happens during the operation, and what do you do afterwards. Under the proposed rule, before stimulation, you would have to file 30 days prior to that. You would need BLM approval. You'd have to file 30 days before you want to commence your stimulation or fracturing operation. You have to include in there a report on the geology of the formation that's targeted, subsurface location of any usable water, and what's called a cement bond log, or CBL. And I have up on the slide there just an example of a cement bond log so you can get a sense of what it looks like. And the cement bond log is used to determine the integrity, basically, of the well bore, to determine whether water-bearing formations are isolated from the well casing in order to prevent the migration of fluids. And if the operator or the producer feels that's really unnecessary, you can try to get a variance under the proposed rules now from BLM. So you would also have to disclose the location of the water resources or sources that you would be used for the fracking operation, The types of materials that you would inject into the fractures to keep them open, and this was discussed earlier. The pressures you're going to anticipate. You would also have to certify in writing, and this provision here has become very controversial among the mostly the industry. You have to certify in writing that you will comply with all applicable federal, state, tribal, and local laws, rules and regulations, permits, and notice requirements regarding the stimulation fluids, which, as you can imagine, if you're an oil and gas operator or driller, this is, could be a major hurdle to overcome. The operators must also submit a detailed description of the well engineering design that would include the volume of fluids to be used, surface treating pressures, proposed maximum injection pressures, and estimated or calculated fracture lengths and heights anticipated. Some of this has been pretty controversial too, because some of this is very difficult to know with any certainty, and certainly not in advance. And just to mention, by the way, we were talking, I know, through this entire symposium about the water usage, and this really is a local issue, but just to put a sense of the quantity of water that's being used in fracking, it's really not that much. I mean, you can take, I mean, I have a site in my briefcase if someone's interested in it, but if you take 2.5 hours of the flow of the Mississippi River, just over a 2.5 hour period, you can supply all the fracking fluid that's needed at the maximum requirements for all wells in the U.S. right now. So it's not really a huge amount of water when you compare it to some other uses of water. Before the stimulation, the operator must also provide a description of the handling of the recovered flowback, an estimate of the volume of fluid to be recovered, and the methods for the management and disposal during that flowback operation. And then you have to describe the method of disposal, whether you're going to truck it off or use a pipeline or inject it. The BLM has a right to request additional information. The operator also has to perform what's called a mechanical integrity test that basically will emulate the conditions that you expect to face when you actually go forward with the stimulation or fracking. During the fracking now, so we're done with, and this is just a highlight. You have to read the draft rule if you want to get all the details. So during the fracking, the operators are required to store recovered fluids in the tanks or line pits. They must continuously monitor the pressure during the fracking operation. And if during that operation the annulus pressure increases by more than 500 psi, the operators have to orally notify the BLM as soon as possible, file a notice within 24 hours following the incident, and follow it up with a written report. You have to store fluids in tanks or line pits. Now we're going to move to after stimulation. So within 30 days after you complete the stimulation, you have to submit a report to the authorized officer that will allow BLM to determine if the fracking operation was carried out as anticipated. So you have to report on the depth to the perforations in the open hole areas, actual sources of water, your actual volumes used, the actual pressures you experienced, the actual rates at which the fluids were used, and then again the estimated or calculated length and heights of the stimulations. And this part is very controversial too. You have to identify the stimulation fluid used by the additive trade name and purpose, the chemical abstract service registry number, and the percent mass of each ingredient used. And what I've put up on the screen there is just a sort of a graphic of the typical component of what you might see in a fracking fluid operation. This format now for reporting the chemicals does not link the additive to the chemical composition of the materials, so you can imagine that's been controversial on the other side of the ledger. So both sides of the ledger here, both the environmental community and those who are opposed to fracking and the industry, this is a very sensitive part of the rule. Then the BLM has said that they're going to place this information on the chemical fluids on a website called FracFocus.org. You know, if you're not familiar with that, you should go online, take a look at it. It's been a popular place for the industry to place this information, and a lot of states rely on it. The operator will also have to certify that they have in fact now complied with all the federal, state, local laws with respect to the fracking fluids used, and they've got all their permits and things of that nature. They have to certify that the wellbore integrity was maintained throughout the operation. They have to report on the final handling of the fluids and the disposal techniques they used. And then they have to basically explain any deviations from the approved plan. Okay, on the chemical information that's being reported or any other information, you know, you can seek exemptions from things of that nature, absent or some type of confidentiality on protecting trade secrets, and in the absence of that, the material will be released. You could also seek variance from certain minimum standards, but in terms of how you're going to operate, but not of the approval process. So BLM also retains the right to rescind a variance or modify any condition of approval due to any changes in the law or technology, regulation, field operations, non-compliance or other reasons. So they do maintain some type of continuing oversight during the operation. The real problem is the lack of staffing. Right now, BLM is understaffed probably by about 20%, and this is just going to add to their burden. I already covered that. You can seek variance from minimum standards for operational activities, but not the approval process. Okay, the rule implementation. The preamble to the rule notes that many states already have rules and regulations in place. In fact, they already enter into MOUs with states to avoid duplication. And this statement up here, which is a direct quote out of the preamble to the regs, is kind of interesting because it says that basically that BLM will be happy to defer to states, and that has been their longstanding practice, to adopt whatever practice is the most protective of the resources. So 5 minutes, I'll be done in 5 minutes. Comments, there were, according to BLM, there were 175,000 comments were filed. Yes, 175,000. So about, a lot of these were, you know, form letters that were put together by organizations, and hundreds of those were sent in, but that's how many comments they tell me were filed. About 200 of those were really of a substantive nature that were meaningful to read. And I've listed, to be fair about it, 4 on each side of probably, you know, ones that would be interesting for you to take a look at and read. And the IPAA filed comments on behalf of itself and about 45 other oil and gas trade associations across the U.S. And NRDC, National Resources Defense Council, filed on behalf of itself and about 35 other organizations. And notably, I think that the Committee on Natural Resources, U.S. House of Representatives, filed comments also. So that's it. I'll be happy to take questions after we're done.
Well, thank you for having me. I'm Chris Kulander. I'm from Texas Tech University. Before that, I was 6 years private practice. I'm also of counsel with Haynes and Boone, which is based in Houston, or my office was in Houston. I guess the firm is based in Dallas, the home office, as we call them. What I'm going to talk about today is where the state's going, and if I have enough time at the end, a couple of slides on will the EPA let them, and maybe compare to how fast the EPA moves to how fast some of the states move. So while I'm going through this, keep in mind how fast the states are moving in contrast to maybe the EPA in some circumstances. Inside the material you have a, I think it's like a 112-page long draft paper that is coming out in the Rocky Mountain Mineral Law Foundation. I think it's the longest paper that I know of on this, on hydraulic fracturing. written by 3 partners and me when I was an associate. Can you guess who did the most work? Yeah, and I'm sorry there. But it should be available with some changes in a couple of weeks, and there you go. Hydraulic fracturing in a nutshell, it's kind of the problem. We have these formations that are about as tight as the concrete outside, and they've got some oil and gas in them, and it's like I would say a sponge that you can't squeeze. It's maybe not that full, but it's got a lot of, in the aggregate, a lot of pore space that we can't seem to get at. And we learned in the Austin Chalk through natural fracture zones that you can, these fractures where you want to drill. And so they would slant drill. They had some of the earlier horizontal wells. This is down in Texas. I encountered these, and then somebody said, well, why don't we make our own fracs? And using some old technology, and they went with it. Because the fracs or cracks will allow the oil and gas to flow along the boundary. So the solution, man-made cracks to let oil and gas flow. And throughout this presentation, you're going to see a series of pictures that I took on various frac jobs that I've had an opportunity to visit. This is a bridge plug at the bottom of a production zone. So they'll drill through the target formation, perhaps vertically, perhaps horizontally, pack it off so that it's separate, and then set off charges in there to perforate it, and then they'll frack it with a high pressure fracking fluid or gel that's put into the hole and pumped up to about maybe 16,000 psi in some circumstances. And that holds the fracs open. So I think when we wrote this paper, we go through all the states that have significant fracking regulation, and we began to see patterns over and over again. And you can read your favorite states in there, where they're at. It's kind of kaleidoscopic, and eventually your eyes, I call it MIGO, my eyes glaze over, is the acronym. And so I've kind of narrowed it down to 4 primary vectors of regulation. It's where you get the water from, and how much you use. That's the states touch upon that a lot. And you're going to, from the first talk, you're going to hear some repeats of what the states are doing, just like the BLM, because a lot of people are looking over each other's shoulders and see, well, that's a good idea, I like that, and they'll kind of change it around to what they want their state regimen to be. There's well completion requirements, monitoring it, seeing if there's a pressure drop or sudden increase, something that could indicate a problem with the annulus. Disclosure of fracking fluids. This has probably been the most ballyhooed problem that we've had. I think it's one of the smaller problems, potentially. And we'll take a look at a FracFocus example. And then what do you do with the flowback water that comes back? So these are the 4 vectors of invective, we could call it, I suppose. What I'm going to do is give you one state example for each of these. You can read your favorite state in the paper, or just look it up on FracFocus. They have a state-by-state analysis there as well. Ours is better. And the first one is Texas. And at the beginning of 2011, there weren't really any specific state regulations related to disclosure of the fracking ingredients. And then in May 2011, every other year it gets a little odd. Every odd year the legislature meets, so it gets a little odd in Texas. And they passed this form or this law that said, okay, Railroad Commission, our oil and gas commission is called the Railroad Commission, don't ask. And they said, you've got to come up with some rules that make it necessary for you to disclose your information. So you enter the amount of water and chemical ingredients. Trade secrets may not be disclosed if the company can qualify under the administrative code, but non-disclosure can be challenged by landowners or neighbors or adjacent neighbors. They don't really say what that means, but somebody nearby. And then in that case, it requires means to get to an emergency responder, say, for example. Now, FracFocus, this started April 11th, 2011, and it's now, I think, got over several 100,000 wells in there. You fill out a form, the location, how much fluid you've put into it, and what's the chemical ingredients of those things, of the 0.5% of chemicals that comprise the 100% of water, proppant, and chemicals that are put down in there. The site also contains cursory explanation of, you can interactive map and click on West Virginia and see, it might take you to their big fracking area in their state code or something of that nature. It takes you to the law, not to annotated explanations that perhaps a layman might find more useful. Then the well site information and whatnot. Looks like this. I know you can't read that, but this is a well in FracFocus. This one's in Haskell County, Kansas. And you can see they have various columns there: trade name, supplier, purpose, ingredients, chemical abstract, service number, and whatnot. This is a little blow up of what you can expect in there: the well information, its location, and its API number, which is kind of like its individual name or social security number. The trade name of the chemical, which means nothing to me, Plex Break 134. Okay, but they have a glossary that tells you what some of these things mean. So what is that? What's the purpose of Plex Break 134? It's a flowback aid and a breaker. So then you go to the glossary, and what's a breaker? Okay, who supplied it, the ingredients that comprise it, and then its chemical abstract number. A chemist can use that to parse out information about it, and the maximum ingredient concentration. So people said, well, the Railroad Commission, now they got to make a rule. They're not going to get that done for years. Okay? That very same year, they finalized a rule. December 13th, 2011, they released their disclosure rule. And it says that it's kind of the Texas two-step. The service companies have to tell the operator, and then the operator has to release the information via FracFocus. All right? And some other states are using FracFocus too: New Mexico, Oklahoma, Louisiana, a couple. And then a few of them will have their own. Pennsylvania started, I think, their own. Colorado might have their own. And what you have to disclose is a little bit different in each of them, but that's the primary vector of release. So we have 3 railroad commissioners. There they are, coming to the rescue. Okay, not really, but they moved fast. That's the takeaway from this. It's you can see the first comment hearing, public hearing, and then it enacted, just about a month from now, last year. So they move very quickly. Keep that in mind. Well completion, completion requirements. Here's just an example. This one's from Ohio. You have to fill out a well completion report, and it contains all sorts of stuff. When the reservoir broke down, so when the fracks actually occurred, at what pressure level, perhaps the name of the fracking contractor, if it wasn't the operator of record, the pumping rate, whatnot. You can read the information that has to be included in this. And there's some others. You have to provide the log from the completion. And these are very high-tech operations. There's a large trailer next to a lot of these fracking operations with huge computer monitors that you can graphically in real time measure the breakdown of each of the formations as they go through the shots. I was really impressed on the sites that I've gone to. And of course, they knew a lawyer was on site. So, take that into, you don't want to think maybe it's like going around North Korea, you're getting showed the good stuff, but full disclosure, they knew I was there. Invoice for each of the procedures, the methods used, and a copy of the pumping pressure and rate graphs. You need written authorization if you're going to be doing this close to, you're going to have casing that goes through water, aquifers up in the shallow part of the well profile that are going to be used for municipal uses. And the pits and tanks that this stuff flows out in has to be put in a meet specific regulations, and I think they borrowed that largely from Oklahoma, so which had one. West Virginia, what do you do with this stuff that comes back? You might have, and I've read different things in different places, 20 to 40% what we call flowback. I've heard on site sometimes they'll get as much as 80% back of what they put in. It'll be filled with a lot of particulate matter, solids as they call them, and then it'll be pretty briny, pretty salty. That's what the flowback has associated with it. West Virginia, the governor down there was worried that they weren't moving quick enough, so he issued an executive order that said that all Class 2 wells are required to permanently dispose of wastewater from fracking. So you have to use those instead of a municipal treatment plant, which they discovered in some cases was not able to handle what was coming back up. So ultimately, in West Virginia, unlike Pennsylvania, where they have a shortage of injection wells, most of the used fracking fluid that they won't recycle, as one of the previous speakers talked about, are re-injected using a UIC permit into an injection well. You fill out a hydrofracking reporting form. This is kind of similar to what we're seeing in a lot of states. This will have where the well is, how much you injected into it, how much you recovered back out of it, how you treated it, and other information about the well. Once again, you see that code that covers the protective liners for the fracking fluid before it goes in, and the settling ponds where you might have the solids come out before you pump it back in. So that's coming up again and again. What do you do with, where do you get the water? We've gone through a historic drought in Texas. It didn't rain in Odessa for like 13 months, to give you an idea of how gnarly the drought was in West Texas. About 125 miles south of Lubbock, where I'm at. And so the legislature said, okay, Texas Commission of Environmental Quality, you need to define what a drought is, when it starts, when it ends, and then you can control surface surface draws of water during those drought emergency conditions. This is probably something you may not see too much in the Northeast. Water is, of course, more scarce in South and West Texas than it is in the Northeast, so it's something that we have to deal with. It's one of those things that makes one state very different than another, and you need to keep that in mind when you're trying to come up with a model regulatory scheme. You know, this may not be one size fits all across the nation. How long does it last? They can suspend. You have to buy a water right in Texas, okay? It's not like a riparian regime where everybody has a right to equal access, okay? So down there, you might have that water right and you think, I'm good to go. I bought it from Farmer Brown, who's not going to be using it. We're ready to go. And then, as you got that rig planned to come on site, boom, you're suddenly hit with a draw impoundment. You can't pull out of the Brazos or the Trinity or something like that. Okay, that's a coordinator's nightmare in some of these operations. So this was closely scrutinized by industry. Here's a rather dorky looking guy next to a frack water pit in Midland, Texas. The water code exempts oil and gas. This is a state exemption. People are complaining about federal exemption of oil and gas operations. This is a state exemption for oil and gas operations for groundwater. Local groundwater districts are not allowed to mess around with curtailing use for exploration and production. But people, the groundwater districts, are now parsing out fracking operations and saying that those are different than exploration and production, and that they can curtail use of groundwater for fracking operations. Not just groundwater districts, but cities. Now in Texas we have cities and not city. All right, we don't really, they're big, small, but we call them all cities. They can come up with their own groundwater use, like Grand Prairie, Texas has done that as well. Other states that are facing groundwater depletion, and the Ogallala Reservoir and other places are also beginning to consider parsing out fracking operations from this very commonly seen oil and gas exploration and production exception that we see down there. So every state's a bit different. That's common in my neck of the woods. What might a model regulatory scheme look like? I'm hesitant to have one of these on the books because, like I said, it's a problematic as far as the states go with one size fits all. But they would control the acquisition and use, have your production completion requirements standardized, reporting of any abnormalities during fracking or drilling, disclosure of the ingredients. You know, it's not so much that there was nefarious stuff going on in the background, it's that each company put a lot of research and design money into their fracking cocktail. And they didn't want to disclose it and have some Johnny-come-lately come in and say, well, I don't have to spend that, and now I have the information that you spent a lot of money to develop. That's kind of why there was some foot dragging. And of course, the public said, well, we don't care about that. We're worried about what you're pumping into the ground below our aquifers. So there was some friction there, and frankly, I think industry dragged its foot a little bit too long before they established this release scheme. Now I think even though this was the most ballyhooed problem, I think it's going to go away. I think surface disposal of the flowback water is going to be your primary vector of potential contamination. Reaction of environmental impacts by some of the, I have found that if you approach an oil company and say, we have X, Y, and Z problems, they can almost always take care of it beforehand. If you do it during operations, that's bad news. Pad sizes can be down to about 2 acres, and that includes the fracking pond. There's soundproofing methods if you're doing it close to a city. Truck traffic is very bad, particularly in South Texas and parts of Pennsylvania. They'll just beat those roads apart. My grandmother lives in Lock Haven, Pennsylvania, same house for 90 years. And they just tore the state road out in front of her house to pieces. Now it's under constant construction, like most Pennsylvania roads have been in my life. But anyways, reuse of flowback water, whether you can or how much you might have to do it in order to prevent use of too much groundwater. I took this from the top of a sand truck that was pumping the resin-coated sand in the proppant that holds the fracs open. Protection, preservation of groundwater assets. Technological advancements, truck traffic, you might use temporary pipelines instead. That cuts down on it. CO2 slurries would cut down on your water. Drought curtailments, then you would use maybe drill down to briny water, or what they call it livestock grade water. Use that instead. Urban settings, make the pad size smaller, limit your hours of operation. But if you do that, keep in mind that they're going to be on site longer. So it's a trade-off. And then put sound walls around it. Finally, last 2 slides. EPA, and they just released Class 6 regulations. And these are, if we ever went to a CO2 sequestration, the injection wells would be called Class 6 wells. And so Class 1 is industrial use. Class 2, which is accepted, that dreaded Halliburton, scary word, exception, oil and gas use, and so on. Class 6 for a carbon CO2. The initial draft rules came out in July 2008. All right. Comments September 30th in Chicago, October 2008. More public hearings in 2009. Final rule published September 15th, 2011. Okay. So the implementation for a relatively uncontroversial rule took more than 3 years. So just imagine, I'll leave you with this, just imagine how long that process would be for setting up for fracking wells, wells that hydraulic fracturing is used for secondary completion. Imagine how long that would take. So keep that in mind as we go forward. Thank you.
Thank you, Jonathan. I'm John Nolon from Pace Law School. I'm counsel to the Land Use Law Center there, and I'm always curious to know what professors and deans do to get law students to sit until 3 o'clock on a Friday afternoon, knowing what you've been through all week, to listen to a bunch of older folks talk about an issue that you've dreamed up, that you know is a forward-looking issue. And I just want to, when we go out in the rotunda, can you tell me what they did to get you here? I'm sure it's some kind of reward, yes? No? Well, perhaps the reward is your gift to us of this conference, and particularly this CLE book that you did, which is terrific. I assume that was student work. And I can tell you you're leading many, many law schools in this issue. By way of a little further introduction, our law school is ranked fairly highly as an environmental law school. We get Steve Gavin is my RA. He's here with me today. We get a lot of very bright, environmentally oriented students to work with us. Steve has a group of students working under him, and we're trying to do what Chris was just talking about, try to keep up with the regulatory standards that are coming out at the speed of light in this field. I also, for 10 years, have been a part-time visiting professor at Yale in the Forestry and Environmental Studies School, working mostly with master's candidates for environmental management degrees. And the students there are focused very, very intensely on the fracking issue, as are the professors. And Professor Robbins mentioned the ESA as a slumbering giant that's about to awaken. I can tell you that the professors at Yale, all of them in geology and in hydrology and in all environmental sciences, we have one person who is an atmospheric anthropologist, who is, all of them are focused on this issue, the science of measuring the impacts of fracking. So what I would like to be able to present today, which I'm much too smart to even attempt, would be a matrix that has environmental and health risks on the left, and right next to it has the science that is available to assess those risks with respect to hydraulic fracturing. And then the matrix would be a regulatory matrix that would indicate which of those risks are dealt with by existing regulations, federal, state, and local. And my guess is that there would be a huge number of gaps. Professor Merrill mentioned that last night. I said to him at dinner that we think that we've identified about 36 environmental and public health risks associated with fracking. In fact, the number is much larger. Steve tells me that I'm extremely conservative. But again, it depends upon how you do the typology, how you group things together. But if you just take individual risks, there are a frightening number of them. And if you look at the regulations that are coming down from the federal, state, and local level, many of them are not being dealt with. And that tells us something about the state of the law, the state of science, the state of industry. Industry is way ahead of all the rest of us on this issue, and we have to be very respectful of their need to do what they're doing for all the reasons that have been mentioned today, but we also have to be very careful as custodians of the legal system that we have some solution to the problems that are being raised. So my presentation is about the regulatory dimension. You've heard a bit about that today already. Let me start with why do we need to regulate? And I'll refer back to my list of 36 risks. There are chemical hazards, noise pollution, light pollution, methane release, groundwater pollution, groundwater depletion. We've got, thanks to Professor Robbins, we've got forest fragmentation, endangered and threatened species elimination, habitat destruction, surface water pollution, seismic activity, the integrity of the water impoundment systems, stormwater runoff, and I am 1/3 of the way through my list. So, in New York State, where we're paying closest attention, we have a draft generic environmental impact statement that we're looking at on the regulations that are going to be coming out by our Department of Environmental Conservation. It's 1,500 pages long. I have students going through that. I call it a risk assessment document. I have students going through that 1,500 pages, pulling out what the risks are. Because environmental impact statements have to look at the adverse environmental impact of a regime that they're about to come out with, and then list what those risks are, and then talk about how those risks are going to be dealt with, mitigated, yes? So that's the way our environmental impact system works. There were only 80,000 comments that came in on the 1,500-page environmental impact analysis in New York. So I think it's pretty clear that we have at least the responsibility to talk about how we're going to regulate, at what level of government. And what I really want to talk about a little bit is, where does this regulatory responsibility lie? And I want to mention at the beginning that it's not part of my presentation, but involving the industry, and this is incredibly important. We get our information from the industry. The industry is engaged in an effort to try to be responsible so that they don't get over-regulated. They will give us information. They have a lot of information. But I'm just looking at the governmental regulatory side of this. And the question is, who should decide these issues? How should these issues be decided at the federal, state, and local level? And I think Chris just gave us a nice cautionary tale about getting the federal government too much involved in this because of how long it takes them. But if you think about these 36 risks that I'm talking, they're all local. These are all local risks. Within a state like Ohio, the Marcellus occupies the eastern side of the state, so that's important as a state issue. From the federal perspective, there are lots of federal issues, but most of those are economic and related to greenhouse gases and other things that don't really drill deeply on light pollution next to some farmer's home or that road in front of Chris's, was it your mother's house? Grandmother's house. So let's talk a little bit about who should be regulating, and let me do it in the context of what's actually happening. And I'll focus on the 4 states that share the responsibility for the Marsalis, West Virginia, Pennsylvania, Ohio, and New York, and on the federal government, and what's happening at the local level in this jurisdiction that I just sketched out. So we're going to look at federal authority, which, by the way, is delegated to the federal government from the states. State authority, which is pretty plenary because under the 10th Amendment we reserve the police power to protect public health, safety, and welfare, and local authority, which comes to it in the form of either constitutional home rule authority or, by and large, mostly state enabling acts that allow local governments to protect environmental assets and the development of the land. Under the federal government's authority, what we have basically, there's more to this story than what I'm going to go over, but this is pretty much under the Safe Drinking Water Act, the injection of diesel-laden fuels is regulated under the Safe Drinking Water Act. Under the Clean Water Act, the disposal of flowback water into surface water is regulated. And under the Clean Air Act, by 2015, some wells are going to have to capture the methane that is otherwise being released. Now, that leaves a lot of risks unregulated. So let's look at what the states are doing with the remainder of these risks. Professor Merrill, I think, rightly characterized New York as moving very slowly, very cautiously after years of not having to think too much about oil and gas regulation. We have an oil gas solution mining law in New York State, and historically it is the states that regulate this industry and this resource. Our scheme delegates all the regulatory authority to our Department of Environmental Conservation. And the statutory approach in New York is that the DEC will issue regulations. The regulations will guide the permits to be issued by the DEC to drillers. Because under our State Environmental Quality Review Act, we have to do environmental impact analyses on all of our actions at the state and local level. DEC is completing this draft generic environmental impact statement that I talked about, which has been going on for 4 years, and the governor has come under a lot of pressure from a lot of different people in the state, and he just recently decided to appoint, through the health department, a special advisory group to deal with the public health impacts. For those of you who follow impact analysis in environmental law, there's a lot of dispute between what is an environmental impact analysis and what's a public health impact analysis. Different people are experts in the two different worlds, and so now we're seeing that come to roost in New York after 4 years of having our Department of Environmental Conservation do environmental impact analyses of their regulations. Now we have a very unbelievably sophisticated advisory group in public health engaged in another analysis of these regulations, and that was just set up in 2012. And Governor Cuomo has said, I don't care how long it takes, I'm going to get it right. Now, there are many things going on with his political agenda, but I believe that that is, in fact, his core value here. So New York State will be giving you a model that, when it does come out, I think is going to be very articulate. Now, there's jurisdictional confusion in the law in New York State, as there is in the 4 states that I'm going to talk about. The oil, gas, and solutions mining law, this is a quote, supersedes all local laws or ordinances relating to the regulation of the gas mining industry, but doesn't supersede things like local jurisdiction over roads and real property taxes. Thanks a lot, the state legislature. Now, you read that on its face, and it says local governments are out of the picture, because the regulation of oil and gas is superseded to and given to the state. But it raises some questions about whether it preempts local zoning. Our communities, advised by some very good attorneys, many of whom I know, went ahead and regulated oil and gas under their zoning power. the town of Dryden zoned to prohibit, quote, the exploration or extraction of natural gas anywhere in the town. The town of Middlefield amended its comprehensive plan and zoning to prohibit heavy industry, including gas drilling and wells, anywhere in the town. So, of course, there was litigation. Here, the community is regulated, and the, in one case, the dairy operation that had leased out its land to a drilling company sued, and in another case, the drilling company sued. And in both those cases, the local courts, in very, very ably articulated language, held that the local governments, under their delegated zoning authority, can regulate the location of gas drilling, while DEC has exclusive jurisdiction to regulate drilling operations. The cases are being appealed. Now, let me take a minute and try to sketch out for you legally what's going on here. A law that tells the State Department that it can regulate gas drilling is saying that the purpose there is to promote the use of the resource, to be sure that it's not done wastefully, and to be sure that the public safety is taken into consideration, as well as the workers. So what oil and gas regulation does, if it preempts the field, you can logically say, well, they've preempted the field of regulating the operations, the manner and method of drilling. But to say that legislation takes away the historic power, home rule power in some cases, of local governments to regulate what happens under their comprehensive plans and under their zoning, and to require that they put gas operations in their community wherever the gas driller decides to get a lease, that's not necessarily what the legislature was thinking about. The two systems can exist simultaneously. They overlap. And where there's overlap, there may be preemption in favor of the state. But we have to be careful that we don't see both of these spheres of regulatory influence at the same time. So what simply the court said, based upon a lot of precedent in New York under the Mining Law and Reclamation Act of the state of New York, is that all that was preempted was the regulation of operations, the manner and method of drilling, not its location. And all of these concerns that are logically land use issues and zoning issues, those are still the prerogative of the local government. They can still decide where these things go within their border. So I'm going to skip this slide. And in Pennsylvania, the Oil and Gas Act seemed to allow local governments to regulate, and there were cases that said that it did under zoning. But then Act 13 was adopted earlier this year, I think, 2012, and it specifically preempted local regulation, including zoning, and required local governments to amend their zoning to allow gas drilling in every zoning district at the local level, Act 13. Under the Robinson case, the court in Pennsylvania held that Act 13 was a violation of substantive due process, that it was arbitrary and irrational, and that it introduced incompatible uses into a legal system under the municipality's planning code that was designed to create a system at the local level, including the adoption of a comprehensive plan and zoning that had a logical approach to it, and that this insertion in every single zoning district of oil and gas as an allowed use violated the substantive due process rights of the local landowners. So now we go back to the Huntley and Oakmont case and the Range Resources versus Salem cases, 2009 cases, which were handed down on the same day, that said prior to Act 13, which is now invalidated with respect to this preemption issue, local governments could zone gas out in certain districts, but they couldn't regulate operations. Okay, now in West Virginia, the statute gives primary responsibility for protecting the environment to the state, and local governments are told they should support the state, and the language there also sounds very preemptive. And there have been a couple of cases that say that the local governments in West Virginia don't have the authority to regulate. In 2012, Morgantown City Council amended its zoning law to prohibit drilling within 625 feet of any structure, effectively prohibiting drilling in 98% of the city. So that's going to be reviewed. And again, although in West Virginia and now Ohio, it seems like the state statute is preempting local authority, there's still this other realm of regulation that that exists. In the West Virginia case, the court held that there is a method that we use to interpret preemption that is called conflict analysis. And we try to see whether or not there is a conflict between what the local government is allowing and does and what the state is allowing and does. And if they can't find the conflict, they won't find preemption. So in Ohio, recently, the law was amended to give sole authority, as Professor Robertson said, of permitting to the state, including the location and the spacing of wells within the state, and we've got some cities that are moving forward. So what we have in all 4 states, I believe, is law that is not yet settled as between state and local authority. And it seems to me that this raises some major questions for us strategically as lawyers as we think about this issue going forward. So let me find my notes for my concluding slide and ask you a couple of questions, you law students who stayed until after 3 o'clock on a Friday afternoon, about the future of our legal system. If you listen to most professors talk most of the time, and most lawyers, we kind of get into these silos, right? When I ask who should decide, you immediately say, well, it should be the federal government. No, it should be the state government. No, it should be the local government. This is our federal system. Our federal system is challenged with respect to many issues to be able to figure out some kind of cooperative way that each level of government can bring its resources and its talents and its processes to bear on problems. We saw that go awry with Katrina, and maybe we fixed that. But the idea that each level of government should have the authority over, exclusive authority over a particular matter is foreign to the way that we solve problems. Who has what resource? Who has what knowledge? Who has what power under our legal system? And so a number of things are beginning to happen where we try to figure out how the state of New York, for example, could work with local governments. And under the draft generic environmental impact statement, it says that if a local government has a comprehensive plan, they thought at the time that local governments had no authority to regulate, but they were looking at this and they said, well, if local government adopts a comprehensive plan that shows some concerns for fracking, then you driller go to that municipality and negotiate with them before you come back to us for your permit. With respect to our utility siting, when we issue a permit in New York State, we have people from the local area involved in the permitting decision. So maybe the critical question is not which level of government should decide, but rather how decision-making can be shared, and importantly, how to build industry representatives into that. So that's really your challenge as a new generation of attorneys and hopefully some of you law professors as you deal with this and other issues. Thank you.
So this has been a fantastic group. I really want to thank the organizers and everyone here. It's been, I presented at Cornell and I've presented at West Virginia, and this is a polarized topic in every region that there are shale plays. And it's a complex topic, and I think the more that we continue to share information with each other and dialogue and identify issues, the more we're going to cooperate, as John identifies is very necessary. So who decides is the enormous regulatory issue at hand. And it also brings with it a sub-issue of how issues are framed. Based on where the decision is made, an issue can get framed in a different way, and based on who is in that decision-making body. So I think procedural rights are important to and can drive the process of what substantive protections do or don't come into play. So that said, in the context of procedural rights, two of the key ones are access to information and inclusive involvement of non-state actors in decision-making processes, both from the industrial end and from the civil society end. So looking at this not as a siloed discussion from each individual expertise, but as a coming together of people with different expertise and a intermixing of dimensions, we can look at this as a climate, energy, and water issue, and we can look at this as an economic, social, and environmental issue. And I think unless we do that six-part matrix and look at it from the regulatory perspective, from the economic perspective, from the social perspective, we are not going to really reach agreement on this. So some of the components of that are that methane is 21 times more potent than carbon as a greenhouse gas, and yet it is more short-lived in the atmosphere. So you've got a short-lived climate driver like black carbon, which is just plain old soot, that can, in the short term, impact our climate game to a greater degree than some of the long-term decisions that are currently being considered. And right now, we're looking at, the scientists are now saying that the new IPCC report, the International Panel on Climate Change, the consensus from the global scientific community, is indicating that, the report's coming out in 2013, it's an amalgamation of a lot of the scientific studies, that we're aiming for 6 degrees Celsius. And yet the scientists indicate that we really ought to be at 1.5 degrees Celsius, and that this is having impacts, particularly in the Arctic, that are starting to play out in a way that is shrinking the time frame. You know, what was considered perhaps something that grandchildren would see or future generations would see is now starting to happen already. And so, this Arctic issue is also a methane issue. So what links the Arctic to the hydraulic fracturing discussion is this discussion of methane. And we've been focused primarily at a lot of regulatory levels at putting a price on carbon. And that's necessary and that's important, and we're starting to experiment and be creative with carbon markets. But there are multiple other greenhouse gases. They're the 6 ones that are part of the UN Framework Convention on Climate Change, and then there are new ones that are being identified, including black carbon. And so in the methane context, we may end up triggering a feedback loop, particularly in the Arctic, that will make the discussion on what methane emissions occur in hydraulic fracturing academic. And yet that triggering impact occurs through temperature. So if we, through anthropocentric activities, through human activities, get the global temperatures to a certain threshold, then natural loss of methane in the Arctic as permafrost melt will start kicking in an order of magnitude more climate forcing behavior in unpredictable ways and start impacting currents. And that's what the scientists are beginning to say. So procedural rights, the 2 key ones I identified, access to information and involvement of non-state actors. If you look at access to information in the hydraulic fracturing context, which I'm going to expand to the unconventional natural gas context, because it is very true that hydraulic fracturing is one small element of that process, whereas unconventional natural gas is a larger frame with which to have this discussion. In the unconventional natural gas context, scale of externality matters. And if you've got a very localized context of benzene, say, getting in a local water supply, that ought to be looked at a local scale. If you're looking at methane releases as one of the key greenhouse gases, that affects the public good of a stable atmosphere at the global scale. And it being a global public good, it has global ramifications in a collective action process of trying to, as we have been at the international level, coordinate on bringing down carbon dioxide, methane, and other greenhouse gases. And this coordination process is a collective action problem, as economists will identify. We've got a free rider issue, and we've got a this doesn't behoove anyone until everyone acts together issue. Arguably, one of the best ways to start coordinating and cooperating is through information sharing. And I am particularly impressed with the cooperation occurring with EDF, the Environmental Defense Fund, and Southwestern. And we're taking two sides of this issue. One of our key, most respected players in the environmental protection arena, and one of the key hydraulic fracturing entities out there. And they're working together to try and explain to the public the various different ramifications of hydraulic fracturing and unconventional natural gas extraction. EDF is now also collaborating with the University of Texas to do a study on the natural gas link to climate. We've spent an awful lot of time in academic and public media discussions, industry discussions on the content of the hydraulic fracturing fluid. And it's an important discussion. It's a really important discussion. We don't have the data at present to fully understand the climate connection. And so in the absence of that hard data, there's been an absence of a conversation. And I think it's important to have the conversation that we need to get the data, and we need to work together to figure out what are the dimensions of this issue. And I think it's a great good step that University of Texas is now engaged in this. And we've got Cornell data. We need to build on that. And in the if we're still on the Bali roadmap for international climate cooperation, it involves mitigation, bringing down greenhouse gases, adaptation, adapting to events like storms that have been coming more regularly, Sandy, Katrina, others, storm surges in the Pacific, all these collective extreme activities, mitigating to the best of our abilities to them. And 3 and 4 being technology transfer and finance, funding of research, funding of technology transfer, funding of mitigation, funding of adaptation. And so for the unconventional natural gas context, I see that involving cooperating with the state and non-state actors to identify what methane is being released. And that's not only leakage, what's accidentally being released, but what's being vented, what's being off-gassed, what's being flared. And at the US level, you have an effort to take the large emitters, and at present they can combust, but by January 2015 they will have to capture. Now that's not necessarily at present fully economically viable unless you're, say, already close to a pipeline and you can turn that straight into a revenue stream. It's clearly usable natural gas, but you're not always in a location where you can transport it, which makes it comparable to the dilemma of getting, say, wind power from the Dakotas to some usable demand source for electricity. The transmission line problem and the natural gas problem, when done in rural locations, are similar in terms of transporting supply to locations of demand. If you are not necessarily a huge stationary source, then it's not clear, it still remains an open question, the degree of natural gas release, venting, flaring, accidental leakage, that's going to continue to occur with smaller operations that are portable, temporary, and regulated in very different ways across various different jurisdictions. And under the Clean Air Act, we have an effort to try and reduce VOCs, volatile organic compounds, but it's a cooperative federalism approach. The federal legislation under the Clean Air Act is done like the Clean Water Act in connection, in collaboration with states and local governments and tribes. And that for hydraulic fracturing is an open question to what degree the methane is going to continue to be released and at what quantities and at what levels that's then going to contribute to greenhouse gas that would either offset or not offset coal, or more importantly, offset or not offset renewables. So roughly half the states in the country are trying to incentivize renewables through renewable portfolio standards. 20% renewable by 2020 is kind of an average. Different states are doing different things. But that process is impacted by the very, very low price of natural gas. Natural gas extraction is impacted by the very, very low price of natural gas. You know, there are entities that are locked into extracting right now who otherwise would not sensibly be extracting at this price. So how do you like putting a price on carbon, which doesn't necessarily have a global market? There is a market for natural gas. It hasn't historically been a global market. It's becoming a global market with the capacity to liquefy. But that too is an energy intensive process, and we don't have that fully. We are Qatar, Russia, Iran are major natural gas players globally. And until recently, we were talking about importing. We were talking about having liquefied natural gas offshore to be able to bring it into the country. We're now talking about exporting. And so if we're going to be a major natural gas exporter, does that job prospects, increased revenue stream, fully in a life cycle analysis, cradle to grave, make sense with regard to water security, with regard to climate security, with regard to public health? That needs to be a not only technical dialogue, but a value judgment dialogue in an inclusive manner across the industry, civil society, academic, and local, tribal, regional, national, and global community, so that we fully understand the scope of the decisions being made. The Stern report indicates that if one does not address climate mitigation, you're looking at roughly a 20 to 30 loss in global GDP. If you do address it, you're looking at roughly a 1 to 2 expenditure of global GDP. So I argue we should be having a discussion of how to utilize that 1% GDP and where does that revenue stream come from. And I think it would be innovative to take the revenue stream that's starting to come out of some of these cap and trade programs and try and redirect it towards things like addressing release of natural gas. So where do I get that idea? It's starting to already be done at a very small scale in some of these programs. So RGGI, the Regional Greenhouse Gas Initiative, has an offset program that involves landfill methane. Nothing to do with hydraulic fracturing, but still methane. And arguably, it would not be all that different to try and link a revenue stream that arguably, I think, should be geared towards climate and not just go back into the general coffers. That if you're getting a revenue stream from a cap and trade, either through auctioning of permits or through just efficiency measures, that revenue stream could go towards trying to increase the actual technology of full combustion or capture in other ways. And the unconventional natural gas context makes it challenging. We clearly could start with things like recycling water and using things like gel, and there are companies out there that are already experimenting with innovative ways to do natural gas extraction in ways that are less impacting of either public health or environmental integrity. Abandoned wells, I think, are an important issue in that context if you're talking water. If you're talking air, I think lack of staffing that we talked about earlier is really crucial. If you're going to do this monitoring and try and aggregate the small players, these are not refineries that are going, they're not coal plants that are going to stay there for 70 years, and that you can specifically look at, say, the mercury impact. They are in their locations for lesser durations, and I think the refractoring context creates complexities for what it means to be a new source, and is new source review going to continue to be an understandable model with temporary mobile hydraulic fracturing and refracking in the unconventional natural gas context. So the World Bank is also working at this at the global scale and is linking in with international climate efforts to bring this into context in the developing world, not only with regard to hydraulic fracturing, but also with regard to flaring of natural gas, generally speaking, because it's very low-lying fruit in the climate mitigation context to try and capture what then becomes a revenue stream if everyone in the industry can be trying to actually pipe it and get it to market. So I think innovation is crucial in this context, and I think climate, energy, water coordination is key to this triple bottom line sustainability construct that we're trying to get our heads wrapped around, the matrix that involves economic viability, social and environmental integrity. And if you're going to try and do it at the local level, you are looking at flaring for now, but trying to fully combust each frac job. If you're looking a little bit further down the road, you're looking at trying to innovate and perhaps do technology forcing like California has done in the car context with the electric car. That one of the roles of regulation in the environmental field is to actually incentivize what is not currently available in the context of innovation. But I still think it's crucial to try and create that revenue stream, because the onus should not be entirely upon, say, the utilities who are already highly regulated, or the large oil companies, to be coming up with the solution single-handedly for what is a public good, a stable climate. And so trying to be creative about where that public stream of funding comes from. I think one of the ways in which you can do this is through utilities, being able to pass that forward to ratepayers when they are paying their bills. Anyone who's even contemplated the idea of putting solar panels on your roof knows that it's an expensive proposition. Whereas a public utility is able to say, all right, we're going to invest now in what we know is expensive, and it's going to slowly come out of the revenue stream that we get through our utility bills. So I think if we start talking in this manner and start bringing in the communities that are talking about the human rights implications of energy siting with the public utilities who have the deep knowledge in energy extraction and transmission and utilization, along with all elements of governance, we can start putting this together in a coordinated manner. Thank you.
We now have time for questions. As before, please come to the microphone if you have questions for one of our speakers. And I was going to take the moderator's prerogative of throwing out a question for any or all of you that would like to address it. And that is just wondering if any of you have reactions to the comments that Tom Merrill made this morning, suggesting that when we think about how it is we control the possible consequences of hydraulic fracturing and how we regulate the behavior of those engaged in that, that thinking about ex post liability rules and an administrative structure that perhaps supports or reinforces those rules might be a better way to go than ex ante regulation and trying to anticipate all of the sorts of problems and the controls necessary to avoid those problems. And I was wondering if anyone on the panel has any reactions to that suggestion in terms of how we should think about these questions.
Just really quickly, Jonathan, I think at the end of the day that if you look at some of the regulatory standards, particularly the disclosure standards and information gathering standards that are already being found in the laws of the states, that there's an interesting relationship between those and the tort action analysis that Professor Merrill talked about, that if we can begin to think of how the regulatory regime could responsibly gather information that identifies responsible behavior, then we can identify what's negligent, and maybe we can even begin to think about what we ought to be strictly liable for. So it seems to me that his ideas should inform the regulatory, but not replace the regulatory approach that we're talking about.
Anyone else on the panel want to jump in?
I think it's worth just saying one more thing about water in terms of ecosystem services and the degree to which the Catskills provide a very economic water supply, and that if you're not looking across the picture, if you're just looking ex ante within the silos, you can sort of either not identify the need for regulation within a single thread, but if you see locations where there's no current regulation, I mean, clearly don't build in the Catskills, but that's not the same thing as the kind of regulation you'd identify as ex ante or ex post. So being able to see the tapestry and identify the colors in the tapestry is in part seeing what's captured, what's not captured, but also what's just already working in a way that has minimal legal dimensions already.
Yeah, and maybe I'm saying in part the same thing. I think the ex post strict liability is a good idea at some point down the road. I think one of the benefits of what's going on right now is it brings the industry and all the other stakeholders together to try to focus in some type of structure to use on a going forward basis, and I think that's healthy for everybody involved. So I think the strict liability notion is a good idea, but maybe it's premature.
I don't need a mic, I'm from Buffalo. I get the money up front. If anything like proper abandonment and plugging of wells has taught me is if there's some kind of mechanism that they're going to have to do something down the road, get the money perhaps up front in
Like
a bond.
bonding mechanism?
Yes, and that would be, I think, functionally the most proactive thing in this realm that I would recommend.
Yeah, I mean, on the bond issue, it's interesting. On Indian lands, there's $150,000 what's called nationwide bond, so if you're a producer, you can use anywhere in the country. There's a report that I think GAO came out with in 2009 that in 2000, and those bond amounts were established in the 50s. In 2009 dollars, it would be over $1 million, but there's been no attempt or effort to increase the bond amounts, and there are a lot of orphaned wells out there, as you probably know, and there are some states like New Mexico who actually have funds available to deal with these orphaned wells.
And $1 million isn't for a statewide bond may not be much, particularly if this company has a whole portfolio of bad wells and they go bankrupt. Yeah. That won't cover it all when you divide it out.
Right. And the bonds are not expensive. I mean, the bonds I've seen, the cost of the premium is about 1% of the face value, so it's not a huge expense.
Hello again. So it seems that in the regulatory scheme we have either prevention of preventing the act from occurring in the first place, disclosure on the part of the industry, litigation afterwards. What it seems to be missing almost is the inspection, rights of visitation or inspection by regulatory agencies, or maybe it just wasn't discussed in depth. And so I was wondering if anyone on the panel could discuss what type of inspection processes are in place to not only manage the sites and manage what's happening so that we're not solely relying on the information being provided by the industry.
I mean, I can mention, you know, I know from my experience that and I can't be real specific here, but just generally that inspection is a right in most of the laws that I've looked at and that I'm familiar with. I think the real issue is a staffing issue. I mentioned what's going on with BLM right now, where they're already understaffed, and to put on top of them, you know, this notion of looking at, you know, all the hydraulic fracturing proposals that are going to be thrown on their desk is a little bit overwhelming for them. But there's also another side to this that's a little bit bothersome, and that's the competitive aspects of it, because as you raise the cost of doing business, you are making it much more difficult for the smaller guy to compete, the new entrants to come in, and you're really almost walking away from allowing really new competition in the industry. New entrants, I should say.
The third procedural element that I left off is what was mentioned earlier, the access to justice as the Aarhus would define it in terms of the human rights to a clean environment, but what we just call standing and the citizen suits. And I am much more intrigued by the collaborative, earliest stage cooperative process, but ultimately it's your recourse and why it's written into the ESA and why it's written into so many environmental provisions, that when you don't have boots on the ground, you just don't have feet in the departments, that you are by default leaving it up to civil society, and then you have to actually meet the standard of being able to speak on behalf of an environmental concern, not just a personal concern, and that can be a very high threshold without the basic information, without the basic disclosure. So it becomes very circular, and you'd much rather have the expertise and the staff to with the proper credentials to be going out and doing the official monitoring along the way. But we just simply have not resourced our government in that way.
Other questions for our panel?
This question is for Professor Kulander. You mentioned in your comments that Pennsylvania has a shortage of injection wells. So
Yes.
First of all, what are they doing with that contaminated flowback water? And then the second question was, you predicted that surface disposal of this flowback water would be a major problem. And could you elaborate on that?
The flowback well, I'm told the geology in Pennsylvania is very difficult, and as 3 years ago, I heard that you could count on the number of injection wells in Pennsylvania on both your hands, and maybe some toes. I don't know, but apparently it's a geology problem. So you've got recycling is what they do a lot of times. That 20 to 40 or whatever the number is, recycle it. Maybe truck it out and dispose of it in another state. Yeah. I think maybe this state. I didn't. Okay.
New Jersey.
And the third one is somehow treat it on site. And I don't know how they do that, but certainly they take the particulates out. I know in West Virginia they've had some problems with them not being able to. They dumped a whole bunch of this into a sewage treatment plant, and they weren't equipped to take care of that. Those are the three vectors and some weaknesses there. It's reuse, recycle, and then ship it off to some other person or state who gets rid of it. And then you had your second question was, and it just went right out of my head.
Surface.
What?
Service disposal.
Oh, service. Yeah. I think that's the primary vector of trouble, because disclosure. There's going to be ingredient disclosure. There's going to be, well, you're not disclosing enough, or you're using a trade secret exception too much. That'll iron itself out with time, I think. I don't think that when you inject unless there's a casing problem or maybe an abandoned well, when you inject into, say, the Marcellus at 10,000 feet and there's an aquifer at 300 feet, I don't think that there's really a lot of chance that you're going to get aquifer contamination. So I think those two are and when I hear aquifer contamination, a lot of it's anecdotal and it sort of really melts under the glare of good scrutiny. But the surface, the issue, you've had, like in Dunkard Creek in West Virginia, somebody just dumped a whole bunch into that creek and there was a huge fish kill. So you have either a mistake or an unscrupulous operator. We have seen documented examples where where there was a real bad scene caused by whatever their actions were. So it's just looking at the evidence, it looks like that's going to be the biggest problem.
Other questions? Jeff?
I'll speak loudly here. When you can burn coal at 11 cents per kilowatt hour, and we have this celebration we were talking about earlier about natural gas, and $2 per cubic foot, and that's what's really, I think, driving it is the price. And that's from the consumer side. But the consumer doesn't recognize what the true cost is of burning the fossil fuels, the cost to the environment, to climate change. And there's a comment made here that we need to do something perhaps modified with cap and trade to reflect what that true cost is. We heard earlier from Tom where he said that this was tried in Europe, and the jobs went over to Asia as you increased what the cost was of burning fossil fuels. So I guess that's where I'm dealing with this conceptually.
So intriguingly, we've now got discussions underway at the international level for a mercury treaty, and likewise EPA is acting on mercury, which in addition to the price of natural gas is impacting the closing of older coal plants. It's a combined effect there. So it's true that when you look to a given public health issue like mercury, which like lead, one of our huge success stories in this country was getting lead out of gasoline. And it's still not out of gasoline in many other countries. Whether you can get that momentum to talk about mercury and the bioaccumulative effect in terms of eating fish and all the other ramifications of mercury, and address coal in that manner is an untold story. It's still unfolding.
Anyone else?
I mean, I don't think, I guess your question wasn't answered, and I don't have the answer off the top of my head. I know there are studies out there that look at the price impact of various levels of carbon tax on, on the fuel source. So, I mean, they're out there. I just...
my concern is from the global perspective. Is
right.
Businesses can't make a go of it here. If they're going to have to spend 15 cents per kilowatt hour, are we encouraging businesses from which to go to China that don't have these environmental regulations? So, and that was something that Tom had mentioned.
Well, yeah, I mean, I think there's even just bringing it down, drilling, not to use it, maybe drilling, I guess is the wrong term, but like to bring it down closer here. I mean, the states look at each other in terms of what they're doing on even the rules they're putting together on hydraulic fracturing. And when you're sitting there with industry, or you're sitting there with stakeholders, maybe you don't see this in comments filed, maybe it's not in the public, but one of the bigger discussions is whether you're driving away or attracting business. And this is on a state, state versus state, federal land versus state land, private land versus, Indian lands or whatever. So
I'd say China's putting into place some pretty impressive laws. And the World Bank is working heavily with China on coal, both in the mercury context and in the capture context. So I'd say that, and they care deeply about the urban air pollution issues. So while that has yet to fully play out in terms of the legal regulations having an impact on the illegal coal mines that are opening up weekly, it's still part of the story that Asia's not going to necessarily be the viable place either.
Yeah, this is for Professor Nolon. I was curious if you could comment on CELDEF out of Mercersburg, PA, the Community Environmental Legal Defense Strategy for communities adopting Bill of Rights like Pittsburgh did to keep fracking out of their community. That human beings are entitled to clean air, clean water, and renewable energy. And I think Yellow Springs just adopted it here in Ohio. If you could comment on their approach.
I spoke about two areas of regulation, one zoning and land use planning, and the other the regulation of oil and gas industry. And I indicated there was an area where they overlapped, and that's where the tension occurs. When a community bans fracking, and some communities perhaps can validly argue that they should because they're all developed as residential neighborhoods and commercial neighborhoods. But when a community does that, and if communities do that one after the other, I can't imagine that that isn't preempted by state legislation, which is designed to further the production of the resource. So it seems to me that the strategy for local zoning authorities to take is to be a lot more thoughtful about where they can allow fracking to happen locally and where they want to prohibit it next to schools and daycare centers and hospitals and nursing homes and densely developed residential neighborhoods. And if they start just banning it, I think that's a failed strategy long term, because this resource is so desperately needed by so many important stakeholders in our society that it is going to be developed, and I don't think that states are going to allow municipality after municipality after municipality to ban fracking.
I just have a quick question. Well, first off, a comment about the graph where it showed percentage of the fluid that's in, you know,
Oh, yeah,
the
I put that up there.
proprietary nature. I just would like to comment that that's a little bit of a misnomer, because, you know, like we measure nitrate and phosphate and mercuries and all those things in parts per billion, parts per trillion. So as you can't really look at it as a percentage of a gallon of a tank of water. You have to look at it as like threshold limits. We talk about tipping points in ecosystems all the time, and nitrate, phosphate, you all know if you live in Ohio, the Maumee River. Well, phosphorus in the algal bloom that caused that, or that was caused by that, that's parts per million changes in phosphorus in the water. So it's a little bit of a misnomer. But my second question was for Ms. Burleson. Have you ever heard of the CLEAR Maria? Yeah. And could you comment on that? The
Okay,
CLEAR
so
Act?
it may be an acronym for more than one thing. The CLEAR that I'm familiar with.
Senator Cantwell's Act?
Okay, so then it is, because the one I'm thinking of is the international one for environmentally sound technology transfer.
Yeah.
And
comment on that, I guess?
it's what I've been deeply involved in at the climate negotiations, in trying to flesh out the technology mechanism and the creation of innovation hubs that would be regional and able to gather both individual innovators and universities and entities like development banks and venture capitalists, and work together on either patent pooling or open source, like the Linux community, in the context of what's now the operating system for any Mac users. You can see innovation occurring in a myriad of different ways, and what has worked in the public health context for getting AIDS medicine to Africa has some complementary themes, but is very distinct from what would work in different aspects of addressing climate. And so really having innovation hubs is now seen as a very crucial way of bringing the international community together. And CLEAR is the current acronym for, you can find the website for the current clearinghouse. It's an online clearinghouse where you can upload and download blueprints for different designs, and it could become a much bigger concept than it currently is. It's very embryonic, both in its governance and in its substantive provisions. And right now, it needs to be highly spoken of by many more people and funded for it to become a big concept. Right now, it's a exciting embryonic concept, but it has huge potential.
Any other questions? Well, I'm going to turn it over to the editor-in-chief, Ben Ristow.
I'm Benjamin Ristow, editor-in-chief of the Law Review, and on behalf of the Law Review, I'd like to thank all our speakers and moderators today. I think a large part of what makes a program like this so valuable is the diversity of viewpoints, and we certainly got a lot of unique views today, and we're eager to publish the papers that we get from our speakers today. I also want to thank Paul Janowitz, our symposium editor, who did an outstanding job of organizing the speakers today. And I also want to recognize the Law Review staff. They're truly outstanding people. However, if Professor Nolon asks how we induced you to stay until 4 o'clock on Friday, I encourage you to lie. And thanks for everyone for attending. Excellent questions, and I want to invite all of you to join us in the rotunda for a